Welcome to the Speaking Your Lingo podcast, where my goal is to help this generation think well. My name is Shane Lingo, and I'm happy to be back with you all today as we look at what has the potential to be a landmark Supreme Court case coming up this month. Now, there's been a lot of talk in the news concerning education lately, especially with President Trump's executive order, which aims to transfer control of educational policies and decision-making from the federal level to the individual state and local level. And there's a lot I could say about that, but I want to talk about something just as important going on with the judicial branch. Okay, so here it is. Later on this month, we have another big Supreme Court case by the title of St. Isidore of Seville Catholic Virtual School versus Drummond. This is an important case because it has the potential to change how we think about and pay for religious schools in America. Overall, this case will cause us to wrestle with the question of how should we understand the idea of separation of church and state. And so throughout today's episode, as we talk about this case, that is one of the big questions that I will be answering. How should we understand and practice the idea of separation of church and state in the United States of America? Now, in order to understand this specific case, I feel the need to give you a little bit of background information and some context. So, with that, all of this started when a certain group of individuals decided that they wanted to create an online charter school called St. Isidore. And so the school applied to the Oklahoma statewide charter school board for a charter. What makes this situation unique is that you can probably tell by the name St. Isidore that St. Isidore is a Catholic charter school. And in its application, the school was very clear that it was going to be a religious school and that it was going to have religious instruction. Religious instruction ultimately would be taught by the teachers, and religious ideas and focuses in their classroom, all of that would happen. So they applied to the Oklahoma statewide charter in order to get a charter so that they could start this school. And right here, I feel the need to give a little bit of a helpful clarification, especially for many of those who aren't super involved in education. But traditionally, we hear about three different types of schools in K through 12 education. You have your public district schools, and these are your normal everyday neighborhood public schools. Then you have your public charter schools, which have traditionally been secular in nature. And then you have your private schools, and those are often either religious. On one hand, you have a lot of religious private schools, or they can also be secular, like many of the other public schools that we see. Now, the major difference between the public schools, including both charter schools and district schools, and private schools is that public schools, including those charters, are funded by the states and local communities from taxpayer dollars. And so this brings up a lot of questions when we look at this situation because St. Isidore, again, is applying for a public charter. So St. Isidore applied for a charter as a religious school, and the Oklahoma statewide charter school board granted that charter. They said, yep, go for it. You can do this. Well, the Attorney General for the state of Oklahoma, Attorney General Drummond, then sued the Oklahoma statewide charter school board, saying that by granting the charter, it was unconstitutional under the U.S. Constitution, as well as the Oklahoma State Constitution and numerous other Oklahoma statutes. Then, when the Oklahoma Supreme Court heard the case, they ended up actually agreeing with the Attorney General's office, and they struck down the charter school board's charter. At this point, the Oklahoma statewide charter school board asked for an appeal from the United States Supreme Court, and the United States Supreme Court agreed to issue a writ of certiorari and to review the case. And so now this case has gone all the way up to the Supreme Court, and the Supreme Court will be making a decision on this case starting at the end of the month. Now, in order to understand this case, we have to understand the protections we have when it comes to religion found within the First Amendment of the U.S. Constitution. Within the First Amendment, there are two clauses that give us the rights and freedoms we have when it comes to religion. The first is the Establishment Clause, and the second is the Free Exercise Clause. The literal words within the First Amendment are, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So the Establishment Clause essentially means that the government cannot create a national religion that everyone must follow. They can't create the Church of the United States like what we saw with the Church of England. And that's what the founders were concerned with. The founders didn't want to have a national church like the Church of England or to have the U.S. government create a religion that everyone is forced to support. So that's the first clause we find within the First Amendment when it comes to religion. Then you have the Free Expression Clause, which gives us the freedom to practice or to not practice the religion of our choice. And the founders believed people should be free to worship or to not worship how they choose without the government getting in the way, as long as it didn't harm others or break the law in some way, right? Because we know there's limits. There's limits to our First Amendment freedom of speech. There's time, place, and manner restrictions. There's things we can't do things all the time. We don't have the right to say obscene things whenever we want, right? And we have some similar restrictions when it comes to our religious practices or freedoms, especially if it could harm others or break the law in some way. But what they were trying to do is they wanted to protect the freedom for individuals to live out their beliefs. All that being said, there are four key questions the Supreme Court is going to be answering in this upcoming case. And the first question is this: is it a violation of the Establishment Clause for a state to provide funding to a religious charter school? In other words, is it a violation of the First Amendment to have people pay for religious-centered instruction using taxpayer dollars? On the other side, they have to answer these questions. Is it a violation of the Free Exercise Clause for a state to exclude religious charter schools from public funding available to all secular schools? In other words, would this be discrimination on the basis of religion to not provide public funds to St. Isidore Charter School just because of their religious focus? Now, two more questions they're also going to have to answer. First, are charter schools considered state actors or private entities for constitutional purposes? In other words, when it comes to applying constitutional protections like the First Amendment, are charter schools treated like government institutions or are they private organizations? And then lastly, is Oklahoma State Constitution's ban on public funding for religious organizations in violation with the U.S. Constitution? So you have these four big questions that the Supreme Court is going to have to answer in order to come up with a decision for this case. So what I want to do is I want to take some time to share with you how I think the court should answer each of these questions, if I'm allowed to have such a big opinion. Now, this doesn't mean that the court will answer this way, but I want to take some time to build my case for each question while simultaneously answering the question, how should we understand and practice the idea of separation of church and state in the United States of America? Now, let's start with this first question. Would granting a charter to religious schools be a violation of the Establishment Clause? And to this, I would say no. Or at least I don't believe so, especially if we consider the Establishment Clause through the eyes of the Founding Fathers and the generation who created the clause in the first place. And to support this, I want to bring up Thomas Jefferson, because his famous statement of a separation between church and state is what I think is probably one of the most commonly misused and misunderstood references in how we should view the Establishment Clause in our modern day. So let me first start with the context of this letter in which he actually uses the phrase. Jefferson's use of the phrase, a separation between church and state, comes from a private letter that he wrote to the Danbury Baptist Association in 1802. And the purpose of this letter was to reassure the Danbury Baptists that the government would not infringe on their religious liberties. You see, the Danbury Baptists, they were a religious minority in Connecticut in a region that was dominated by the Congregationalist Church, which at the time was still officially supported by the state. So it made sense that they would have this great concern that their own, as kind of this fringe religious society, that their rights would be ultimately violated. And so Jefferson writes back to them to say, hey, don't worry, the Constitution protects your freedoms in regards to this area. The government has no right to interfere with your religious beliefs. And so Jefferson used the phrase, a wall of separation between church and state, to protect the church from the government, to protect the church from government interference, and not religion actually interfering with the government. And those are two different things. Not that the latter can't be a concern. It's just not what Jefferson is speaking to when he uses this phrase, a wall of separation between church and state. Okay, but what I find even more fascinating is the way in which Jefferson lived out this phrase. In fact, when we look back at Jefferson's life, we see that he regularly attended church services that were held in government buildings during his presidency. And within a year of his inauguration, we see that he began attending church services in the House of Representatives. So when we look closely, we start to see a different picture. And when we look at these services, they were Christian in nature, but they also often featured preachers from different Christian denominations. And of course, these services were voluntary, meaning no one was forced to participate. So why is all of this important? Well, these practices illustrate that Jefferson's commitment to religious freedom included not only the protection of individual rights to worship, but also the allowance of religious expression in public spaces, including government buildings. Now, there's another interesting piece of history that helps us to see how Jefferson and some of the other founding fathers lived out the idea of separation of church and state. And it has to do with the ideas they came up with for creating a national seal. So on July 4th, 1776, right after approving the Declaration of Independence, before they even wrapped up for the day, the Continental Congress passed this resolution, and I quote, resolved that Dr. Franklin, Mr. J. Adams, and Mr. Jefferson be a committee to bring in a device for a seal for the United States of America. So Franklin, Adams, and Jefferson were asked to come up with a national seal, and their ideas were pretty creative. The main focus of their ideas were pulled from the Bible that would express what this new nation was essentially all about. In a letter to his wife, Abigail, dated August 14th of 1776, John Adams wrote about what each of them brought to the table. Franklin, he said, imagined Moses lifting up his wand and dividing the Red Sea, and Pharaoh in his chariot overwhelmed with the waters, and suggested the powerful motto, rebellion to tyrants to obedience to God. So that was essentially how Adams described Franklin's vision for this national seal. So what about Jefferson? He saw Americans as the children of Israel in the wilderness, led by a pillar of fire by night. And so when he was thinking about America and what would lead them, he used this biblical imagery as well, looking back to the Old Testament where the Israelites, they were being led out of the wilderness by God, who was represented in the fire, in that same idea of God representing and leading the American people. And as part of this, he also wanted to include the early Britons, the people whose political ideals help inspire and shape America's government. And so he wanted to include those elements as well. And so two of our founding fathers, who are often considered less religious than many of the other founding fathers, are the ones who suggested using biblical imagery to express what the United States is about. Now, as far as Adams, he pitched a more classical idea, Hercules standing at a crossroads and choosing between virtue and vice. And obviously we see those elements represented in the American founders' thinking as well. But the point is that even in designing the Great Seal, these founders weren't just about this idea of separation of religion and politics like many that we find in our modern day. That's not what they were trying to do. They were trying to make a statement about freedom, about faith, about courage, about moral clarity, which to them in many ways were grounded in religion. Now, with that, we see many other examples of how the Founding Fathers included religion within the public sphere, and they were able to connect some of their religious ideas to politics and to public life. We see it in some of the prayers that are done during their inaugural addresses, and there's a lot that we could look to there. But ultimately, what we see with these examples is that the separation of church and state in the Establishment Clause clearly didn't mean and doesn't mean what many modern thinkers today might believe that they do. Now, of course, I want to say that our Founding Fathers were not trying to create some sort of theocracy. That wasn't their goal. But on the other hand, they also weren't fearful of religion impacting our government or politics. It was mainly a concern of government actually infringing on the rights of individuals and of the church. And I love George Washington's words from his famous farewell address that he delivered in September 19th of 1796. He says, "Of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. In vain would that man claim the tribute of patriotism who should labor to subvert these great pillars of human happiness, these firmest props of the duties of men and citizens." John Adams, in his letter to the Massachusetts militia in 1798, also said this: "Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other." Adams believed that a free government depended on people having personal virtue, often that was shaped by religion. So yes, the government can't create a state religion that we must adhere to, but that doesn't mean the government can't fund or financially support religious institutions. And I'll hit on that second part in just a moment. All right, but what about the second question? Is it a violation of the Free Exercise Clause for a state to exclude religious charter schools from public funding available to secular schools? And so to bring this into our modern day, I think it could be especially helpful if we follow the line of reasoning from some of our most recent Supreme Court cases concerning religion and education. A few noteworthy cases that we don't have time to completely go into, but that I want to mention that can help us answer this question. The first is Zellman versus Simmons-Harris, which happened in 2002. And essentially, this was a big win for school voucher programs that included religious schools. Then we also have the case of Trinity Lutheran Church versus Comer, 2017. And this essentially, they stated that states can't exclude religious groups from generally available public benefits just because they're religious. Then we also have the case of Espinoza versus Montana Department of Revenue. This one happened in 2020. If a state provides a benefit to private schools, it must include religious ones too. And then we also have the state of Carson versus Mackin, 2022, which strengthened the rule that religious schools can't be excluded from public benefit programs solely because of their religious nature. And so as we look at these cases and we look at how the Supreme Court has recently ruled, we're starting to see that they are, I believe, recognizing the spirit at which the First Amendment Establishment Clause and the Free Exercise Clause should be implemented, and how the Founding Fathers ultimately saw these things being implemented when it came to the state and when it comes to education. Now, moving on to the third question, are charter schools considered state actors or private entities for constitutional purposes? In other words, when it comes to applying constitutional protections like the First Amendment, are charter schools treated like government institutions? Those would be state actors, or private organizations. And for this, I honestly don't know. I don't know how the Supreme Court's going to answer, and I have a lot more research to do to feel like I could fully answer this question well. But this question, I really see could go either way. So I'll be interested to ultimately look forward and see how the court ultimately responds. As for my part, I have some more time that I need to reflect on this question, think about this question, and ultimately do some research to see maybe how the Supreme Court has responded to schools in the past, or similar situations in the past when it comes to this situation between thinking, are these state actors? Are they private organizations? And it'll be interesting to see their logic if they directly answer this question. Now, for the last question, it really depends on how they answer the first two questions. And that last question, is Oklahoma's state constitution's ban on public funding for religious organizations in violation of the U.S. Constitution, right? The U.S. Constitution is the highest law of the land. If a state constitution violates it, they have to essentially scrap that part of their state's constitution. And we have situations like that all across America if we look at different state constitutions. And mostly we see the states submitting to the U.S. Constitution when it comes to situations like that. And so really this depends on how they answer the first two questions. If they find it a violation of the free exercise clause, then the answer would be yes, it's in violation of the U.S. Constitution. But if not, or if they find the decision to grant the charter a violation of the Establishment Clause, then they would go the other way. So this last question is really going to, I believe, flow out of how they answer the first two questions. But either way, I think the thing to recognize is that the outcome of this case could have far-reaching implications that could stretch beyond the world of education and as a whole could shape the way we interpret both the Establishment Clause and the Free Exercise Clause of the First Amendment. And so I'm excited to see where this case goes, not only for the world of education, but also for our understanding of the rights and freedoms found within the context of the First Amendment, especially in the realm of religion. And this is not because I would even end up sending my kids or have my family a part of a religious charter school. Honestly, there's a lot of great secular charter schools that are out there that function well, and especially a lot in the classical education model that push kids towards truth, beauty, and goodness. And yes, they don't have a religious focus, and they do great things. And so, but that's not really the question we're trying to answer here, whether I would support or send my kids to a religious charter school. But the question is, should Americans have the freedom and the right to do so? Should we have the freedom and the right to create charter schools that have a religious focus and that taxpayer dollars go towards? Or is that only able to be used for secular charter schools and secular district schools and public schools like that? And so it's going to be interesting ultimately to see how the court, where they land and what that could do. It could have vast implications, especially if they uphold the charter school's charter and they say that the attorney general is essentially wrong and that the Oklahoma State Constitution is out of place and all of those things. It'll be interesting to see what this does, not just for this specific charter school, but what this is going to do across America. And then, as I mentioned just a moment ago, I'm really excited to see how this shapes the conversation across the American landscape when it comes to how we view separation of church and state, how we understand the First Amendment when it comes to these two religious clauses that we find in here, the Establishment Clause as well as the Free Exercise Clause. So a lot of interesting things coming up when it comes to this conversation. With that said, overall, I just want to say I hope this conversation has been helpful for your ability to understand these constitutional rights and protections that we have, as well as your ability to understand the Founding Fathers' vision for religion and its integration with the public life overall. And so I hope that this has helped you to be able to think well, even if you don't agree with my position. Now, I want to encourage you to go back and I want to encourage you to read some of these founding documents as well that I've mentioned throughout this episode. I'll have a couple posted on the podcast. I also want to remind you to make sure, if you haven't done so already, to give this podcast a follow. And if you've enjoyed it so far, leave me a review. As always, until next time, thanks for listening, and I'll see you